In Indian polity, we are going to discuss about Article 33 from Fundamental Rights of the Indian Constitution, that is Armed Forces and Fundamental Rights. Okay, so here the Article 33 which generally talks about the restrictions of the fundamental rights of armed forces. Okay, so each and every person has the right to enjoy the fundamental rights which are guaranteed by the Constitution, right? But armed forces they don't have any right to enjoy the fundamental rights, because to ensure the proper discharge of their duties and maintenance of the discipline and maintenance of the secrecy. Okay, so that's why the fundamental rights are restricted to the members of the armed forces. Okay, so total Article 33, it empowers the Parliament to restrict the fundamental rights of the members of armed forces. Okay, so here the Parliament has the power to restrict the fundamental rights of the members who are working in the armed forces. Okay. So whenever comes to the armed forces, there is a Indian Army, Indian Navy and Indian Air Force. Okay, so these three forces comes under the armed forces. And the next one is the paramilitary forces. For example, CRPF, it means a Central Reserve Police Force. Second one is the SSB, it means Sashastra Seema Bal. Third one is the SPG. SPG means a Special Protection Group. And CISF. CISF means Central Industrial Security Force. BSF means Border Security Force. Okay. And intelligence agencies and analogous forces means RA. RA means Research and Analysis Wing, and IB means Intelligence Bureau, and NIA means National Investigation Agency, and CBI means Central Bureau of Investigation. Okay, so these are very important intelligence agencies. Okay, so whenever comes to the intelligence, armed forces, paramilitary and police forces, so there is a maintenance of the secrecy among the details of the Indian government. Okay, so that's why the fundamental rights are restricted to the members who are working in these forces. Okay. So the main objective of the Article 33 is to ensure the proper discharge of their duties and maintenance of the discipline among them and maintenance of the secrecy among them. Okay. For example, according to the fundamental rights, each and every person has the right to speak. Okay. So whenever there is a person who is working in the police forces or paramilitary or intelligence agencies, so the person cannot say anything to the public. Okay, because each and every person has a right to enjoy the fundamental rights. So on the basis of the enjoying of the fundamental rights, so the person who is working in the analogous forces or intelligence agencies, they cannot say the secrecy or secret works to the public, because this is a crime. So being a intelligent, being a analogous agent, he has no right to tell the secrets of the Indian government to the public or to the people. Okay, so there may be a chance to violation or a malpractice. Okay, so here we are talking about the Article 33. It empowers the Parliament to restrict the fundamental rights of the members who are working in the armed forces, paramilitary forces, police forces, intelligence agencies. Okay, so only the power is given to the Parliament, not to the state legislatures. Okay, so it means the Parliament only has the right to enact any laws which are related to the restrictions of the fundamental rights to the persons who are working in the armed forces. Okay, so next important thing is any law which is related to the fundamental rights enjoyment, so made by the Parliament, cannot be challenged before any court. okay, on the basis of the contravention of any fundamental rights. Okay, so because here fundamental rights are restricted to the members who are working in the important forces, okay, because of the maintenance of the secrecy and discipline and the proper discharging of their duties. Okay, so any law which is made by the parliament, so it cannot be challenged in any court. Any court means Supreme Court, High Court, whatever the court is. Okay. Okay, so our constitution given the power to the parliament to enact any law which is related to the restriction of the fundamental rights of the members of the armed forces, right? So on the basis of that power, the parliament enacted some important acts. So first one is Army Act 1950, Navy Act 1950, Air Force Act 1950, and Police Forces, it means Restrictions of Rights Act 1966, Border Security Force Act. Okay, so these acts were enacted by the parliament for the restrictions of the fundamental rights. Okay. Okay, so these Army Act, Navy Act, Air Force Act, Police Forces Act, so these acts are imposing some restrictions on the fundamental rights of the members. Okay, for example, those restrictions are like freedom of speech. So those restrictions on the freedom of speech, there is no freedom of speech to the members who are working in the paramilitary, police and armed forces, etc. Okay, and right to be member of a trade union or a political association, and right to communicate with press. Okay, because whenever a person is going to communicate with the press, so there may be chance to transforming the secrets from government to the public. Okay, so if the secrets are going to be a issue in the public, so there may be a chance to restriction or violation, or maybe a chance to malpractice. Okay, and the next one is and right to attend public meeting or a demonstration. Okay, so the armed forces members who are working in the paramilitary, armed forces, police forces, so those members have not any right to attend any public meeting or demonstration, because so each and every person who are working in the important forces, maybe they have some secrets. Okay, so whenever there is a public meeting or demonstration, there may be a chance to leak the secrets from the government to the public. So that's why they don't have any right to involve in the public meeting or a demonstration. Okay, so here we are talking about members of the armed forces, right? So here members of the armed forces means combatants and non-combatants. It means combatants means the persons who are involving in the forces, the persons who are involving in the war or some important work. Whenever comes to the non-combatants, it means the persons who are working in the area, but they are not comes under the armed forces. It means who are not involving in the war or something work. For example, barbers, carpenters, merchants, okay, chowkidars, bookmakers, tailors. Okay, so these persons also works in the areas of the paramilitary or armed areas, but they are not comes under the combatants, but they comes under the members of the armed forces. So here we are always talking about members of the armed forces. So here members means both combatants and non-combatants also comes under the members of the armed forces. Okay. Okay, so according to Article 33, so Parliament has the right to enact any law to exclude the court martial from writ jurisdiction of Supreme Court or High Court. Okay, so there are some court martials and military law. Okay, so on the basis of the court martial also, there is no writ jurisdiction of the Supreme Court or High Court. Okay, so on the basis of the fundamental rights enforcement. Okay, so they doesn't cover any judgment of the court martial if it is violation to the fundamental rights, but the Supreme Court or High Court don't strike out, or they don't involve in these scenarios. Okay, so it means even the court martial also, they can exclude the writ jurisdiction of the Supreme Court or High Court. Okay.